A quorum is present. Everyone please rise for the Pledge of Allegiance. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Okay. Welcome, everyone. Thank you for being here today. Sorry. I'm so loud that I rarely need this, so I apologize. First off, we're going to go to old business, and that is the response of the state to our question about the legality of our closed session meeting to consider party appointments to the chief judge and judge slots. We do have an email from the state that everyone has been given that essentially says that maybe a hybrid way of handling it is fine, but there was no problem with the legality of the business that we conducted because the slate was discussed and approved at an open meeting, which is what the law requires. As with all things legal, nothing is ever that clear. And we have our county attorney, who is the board's legal counsel, Robert Outen, here today to talk to us about this specific issue. Mr. Outen.
I don't think I have anything that's like, here it is and it's etched in stone. I think you're right. There's gray area there. I will tell you that from my perspective, the goal is to keep you all or the board that I represent out of trouble and to make sure that we do things right. And so I'm really not one to work in the gray areas. I like to keep it straight down the middle in the black and white. As with most statutes, the statutes that we're dealing with now can be interpreted very broadly that allows you to do lots of things, and they can be interpreted very narrowly that won't let you do as many things. And so the way I look at it is, what is it we're trying to do? And if we're going to go into a closed session, why do we need to go in the closed session? And if we know why, then does the law allow us to do it for that reason? Does that mean that you couldn't go in the closed session for something else? Maybe or maybe not. But if the goal is to keep you out of trouble, to not have lawsuits, not have people second guessing, the more that you can do out in open where people can see what you're doing and why you're doing it, the safer you are, the better you are, the fewer challenges you get, and the smoother the election process goes. And so you start with the premise that all meetings of public bodies, of which you are one, are required by statute, by 143-318, to be open. And all meetings are open unless there's an exception. And so really what we're talking about is, are there exceptions that you can look at that allow you to go into closed session to do your business in the back instead of out in front in the public? And really, as you look at 143-318-11, that's the closed sessions exceptions. And the one that applies to you all is number 6, and I think it's the one that was addressed in the information that you got from the state board, and that's to consider the qualifications, competence, performance, character, fitness, conditions of employment, or conditions of initial employment of an individual public officer or employee. And so if you interpret that as broadly as you can interpret it, then you can go in the back and make hiring decisions and do what you want to do and then come back out and vote. I would recommend that's not what you want to do, and that's not what is intended by the statutes and your appointing statutes that look at you and what are the qualifications to appoint somebody, to the positions that you're talking about. And when you look at that, what the election laws say is that you can select from a list of qualified people. And so what is a qualified person? And a qualified person is someone who's a registered voter, is someone who's a county resident, is someone of good reputation, is someone who can read and write, and it's someone of moral character. And so those are the qualifications to serve in the jobs that you all are talking about, your judges and those positions. So you take that and you overlay that with what are the closed sessions exceptions to consider the qualifications. Well, if you read that broadly, you could consider all of those qualifications. But I go back and look at what is the purpose for the closed session exemptions, and it's to prevent the disclosure of protected information like your personnel record and all those things. So when you look at those things, whether or not somebody's a registered voter, I can go back there right now and look, that's a public record. So there's no reason to go into a closed session to discuss whether somebody's a registered voter or not. That's a public record. It's there for anybody to look at anytime they want. Your second qualification is they're a county resident. Same thing. I can find that in 5 minutes, and everybody in the public can. So why would you want to go into closed session and open your door to that scrutiny to have a discussion about that? So that really leaves the good character and the good repute. And that is protected information. If you were an employee already, 153A98 protects all your personnel records because those aren't things that ought to be out in the public and all that. And so when you're talking about good repute and good moral character, if you all have concerns about that, I think that's fair game to go in the back and have a closed session to talk. So you don't embarrass somebody, you don't sully their reputation, you don't do anything to hurt them as you're making your decision. And so the question came up, and I think Karen asked me this in Buxton, what happens if you don't know whether they do or they don't? If you don't know whether they do or they don't, then there's two ways to look at that. One is then there's no reason to go in the closed session. If that's not an area of concern, then it's not an area of concern. The other way to look at it is to go in the closed session and ask each other, is there any area of concern? I don't know which is the best way. My take is that if likely you're going to know whoever is asked to be a member of your board or be one of your judges, whether they have good reputation and good moral character. I expect you all talk to each other, or it's okay for you to talk to each other as long as you're not taught how many, there's 4, 5 members of the board. As long as 3 of you aren't talking at the same time, then you're fine to talk to each other. And so if something comes up among you, you know that there's something about somebody's moral character or their repute in the community, then by all means, make a motion to go in closed session and have a discussion about that. But what you shouldn't do is go back there and say, okay, I guess they've got good moral character. Okay, they've got that. Are they a qualified voter? Yep. Can they read and write? Yep. Was their application timely provided? Yep. Okay, well, we're going to vote to do it. Now let's go out there and just do it. That's really not what's intended. What's intended is if you got the good repute, moral character out of the way, then those other things you all ought to talk about out here and somebody make the motion and do it. If you do it that narrowly, then there's not much anybody could say to challenge what you've done and how you've done it. Again, as I started, you could take a broader approach, and I get that. I mean, I told Karen the other night, if there's 2 lawyers in the room, there's going to be a disagreement. So, and you're going to have 2 on your board. So they may look at it broader than I'm looking at it. But if your goal is to stay out of trouble, your goal is to do as much as you can possibly do in the public so that there's no scrutiny and people can see what you're doing and have trust in the system, then I say do as much as you can do in open session and take those narrow things and do those in closed session. And I think that tracks pretty closely to what the elections board sent to you as well. Questions?
The main question is, was there a problem with the legality of what we did? Our deliberations are a little different in that these are not applications that we approved. These are individuals whose names are submitted to us by party. So some of them are workers that we are aware of. Some of them are brand new people to us, but there's the back and forth on party balance that has to be discussed, which because political parties, according to a number of members from the state, because the political parties of these people are not set out as being okay to talk about, it means that that information is protected, although technically it isn't. But for our purposes, the state says it is. So that was one of the reasons.
I don't agree with that. I mean,
Yeah.
it's a public record. How can you protect a public record? If
I
I can
don't
go
know.
ask for it, then what are we protecting and why are we protecting it?
I guess they're trying to avoid the appearance of politicization.
But
I
the
don't
the
really
statute
quite,
specifically says you have to consider the party affiliation to get balance on your board. And
correct.
so you have to have that discussion. And I don't see anything that's protected about that discussion.
We can provide to you the numbered memo that says it's not supposed to be there. We had to remove it from our minutes, the
Oh.
last meeting. But yes, the question that was put forth was the legality of that meeting. Was there any illegality in us meeting and then approving the slate in open session?
The law is that you have to take your action in open session and you have to have a vote in open session.
Okay.
And so I think if you did that, then the action that you took in open session is a valid action and is the will of the board.
Okay. But
It sort of begs the question as to what you did in the closed session was right. But since the decision wasn't made in closed session, the decision was made in open session, the consequences of having an illegal meeting is that the action that you took in the illegal meeting or in the closed session is void.
Mhm.
That if you had in fact voted and taken your action in the closed session and told Kelly to do it, and you did no more, then that would be void.
Correct.
When you come out of closed session and then you have a discussion and you vote and you follow the procedures and you take action and you have a majority vote in open session, then that's okay. That doesn't mean what you did in closed session is legal. It just means it's not voidable because you did it in open session correctly.
Right. So if I understand what Mr. Outen has characterized for our action, we took our action as a board in open meeting as was required by statute. And the issue of what was discussed in the closed session has a more discretionary interpretation, so that our action as a board was valid in terms of compliance with the statute. And we can take the advice we've been given both from the state and from the county with respect to the nature of our future discussions in future appointments.
I would say that's correct. If the closed session that you took was not a valid closed session, then you had what's deemed an illegal meeting. And if someone called you for that, the remedy for an illegal meeting is that the action taken in the illegal meeting is void. On the other hand, if no action was taken, then there's not huge consequences. If the three of you went out in the back and talked, that would be an illegal meeting and you would be wrong. And a court would sanction you for that and could, fine you or do whatever for having an illegal meeting. But if you didn't take any action from that, then there's nothing to void. And so the consequences are different. And so, again, my view is in the future is to narrowly follow that, do as much as you can do in open session. And then we don't have to get into this debate about what was said, who said it, what did we go into closed session for? Is it legal? Is it not legal? Because there's no point in that because we're not protecting the things that 153A is trying to protect.
Agreed. John, you raised that question. So does this satisfy you?
The impetus for expressing a concern here was owed to our former member's rather adamant objection to going into a closed meeting. And in a discussion that occurred between he and I outside of this room, he informed me that he was very familiar with this matter of closed meetings, owed to the fact that he was the one that entertained the case, the legal issue or the legal case, and made the ruling concerning boards practicing a closed meeting. So based on the fact that he actually wrote the legal opinion or the decision as, I believe that he was sitting as an appellate judge. No, he was,
There's no case law in the
no,
court of case law.
well, with respect to Judge Tillett,
Right.
he did say that he entertained the case, and he then made the decision with respect to this matter of,
I talked to Judge Tillett as well.
okay,
And
so you can better express this than I.
I talked with
Okay.
him at some length twice. I talked
Yes.
to him when he was explaining to me what was going on.
Uh-huh.
I told him I needed to look at the law and look at what was coming from the state board,
Right.
and that I'd get back to him. And I did that, and I got back to him. And I told him that my view of the law was as I've just explained to you.
Okay, so
I
you
won't-
had a.
I
you-
won't say that he was in lockstep, but he wasn't adamant that I was out there in Neverland either. So,
Mhm.
uh,
But there was
and
a
I'm
slight
confident.
difference of opinion
Yeah,
perhaps
so I'm-
in the reading of the law.
I'm comfortable with the opinion that I've given you all.
Right. So I just wanted to clarify that this wasn't a matter of my personal objection to going into a closed meeting, but I certainly want to be in compliance with the law.
Right.
And if there was any, given that he had this concern that he expressed, I thought it best to go ahead and get this
Well,
matter aired out and get the legal advice from both the state and county.
And the most recent legal advice that I have from the state concurs with what I just described to you as well. And so,
Mhm.
to my knowledge, there is no case on point of record that tells me that there's a different interpretation than what I've given you.
Okay, thank you.
And I do want to just add that we did seek the advice from the North Carolina State Board of Elections Legal Counsel. Because in our position as a Board of Election, we actually serve two masters. We work for the county, and we also follow the guidance given to us by the State Board of Elections. So we must get advice from both, which we've now done, and I think that will help us to govern our future
But
meetings accordingly.
that
Sure.
was after we had that closed session meeting, that then we subsequently sought the advice of both North Carolina State and County legal, right?
Correct.
Okay.
Okay.
Thank you.
So, thank you. And I'm always upstairs. And if you need me, tell Kelly to call me. I'll come down and help you if I can.
Thank you for being
All
with
right.
us today,
Thank you. Nice
Mr.
to see
Allen.
you all.
We appreciate your time, sir. Yes. Yes. You may pick up your secretarial duties now.
Car wasn't moving, I could have done them where I was.
I know.
Did Bobby give us anything in writing?
No,
I know we had the papers from the state.
yeah, I believe that he concurs with what the state wrote. And so I think has not given us anything in writing.
No, but he said multiple times that he agrees with the state, and we have that in writing, so.
Yes.
Okay.
Okay.
I just wondered if there was anything for the official record that he handed. Okay, thank you.
All right. Has everyone had a chance to look over the rest of the agenda? Is there a motion to approve the agenda as presented?
I move that we approve the agenda as presented.
Is there a second?
Second.
All in favor?
Aye.
Anyone opposed? Okay. Has everyone had a chance to look over the revised minutes from our September 16th meeting? And I apologize, that was my fault. There were a couple changes made from the original draft. Are they clear to everyone? Is there a motion to approve those minutes?
I move that we approve the revised version of the minutes of the September 16th, 2025 Board of Elections meeting.
Is there a second?
I'll second.
Is there any further discussion about those minutes? Any questions? All right, all in favor?
Aye.
Anyone opposed? All right, we are to absentee ballot review and scanning.
Before I begin, Randy, I can attach a copy of the email from the state with the minutes if you'd like. You
Yes.
have it, so you know what it says. If you want to use that for summary, and then I can also attach it in the minutes if you'd like. And
Okay.
so that documentation is there.
Yeah, thank you.
You're welcome. Okay, so what we have are 2 ballots. That's all we have for this meeting. They, one military and one overseas. So you all have in front of you the various numbered memos that will help you in this process, but you are also emailed that. So you know that what we do with military and overseas ballots that are submitted through the portal, as these 2 were, they're duplicated by a bipartisan team. So we had 2 poll workers of 2 different parties, Lucille Cindy Christie and Thomas Moran. They came in and they duplicated these ballots. So what I have in these 2 packets for you to review is the original ballot that was part of the packet that was submitted through the portal, their waiver and their affirmation and the rest of their packet, their submitted photo ID, because now that is part of the requirement for military and overseas voters as well as the civilian. So that will be there for you to review. And then the duplicated ballot for comparison. And then once you make a motion to approve these, we can put them in the tabulator. And while you're doing that, I can go ahead and open up the machine. So, just so you know that we, after elementary testing, we hear the code from the thumb drive, put it back into the machine, and we seal it. And so the bottom has a seal that will remain until, the end, and we need to remove the ballot. But, we will replace the seal every week. So I'm cutting this off, and we have a log where we're documenting this seal, each time we put a new one on.
Sorry.
Kelly, should we come down and watch you insert the ballots, or does that matter?
You can, that's fine, yeah.
Okay.
Or I can turn the machine towards you, or you can come down, either way. I'm just checking the statement on this, make sure. So, this machine says public count 0, and I'm just gonna open the polls. And the 0 tape is printing. And so I would like for the board to come and look at the 0 tape and then sign it. So we'll do that. And then the next step says go to voting, which I will click. And it says public count 0, insert your ballot. So.
The ballot for Manteo precinct, the one that was submitted online, there's, I guess there's, okay, 2 write-ins. Okay. All right. One, like it was printed. Somebody kick you, Randy?
one member of your party who's not crippled go down and. Is that all right?
All right, is there a motion to approve the two mail-in absentee ballots we just reviewed?
I move that we approve the 2 ballots which we received and have reviewed as a board.
Is there a second?
Second.
All in favor?
Aye.
Anyone opposed? Okay. And so if there's one person, you don't need everyone as long as it's,
I need everyone to sign the zero tape.
ha, Randy.
Sorry about that, and we can't detach it, so I apologize. I could, yeah, sorry about that. And Sandy, these 2 packets need your board chair signature just somewhere beside the date.
Can I do that when I come
You can do that when you come back, yes.
Here we go.
Paving work on 60.
Does everyone have a pen? Need a pen?
Karen, I just don't know what we would do without you. But you. This is like being a chief.
John brought his own pen.
Oh.
Trying to make us all look bad. I'm going to stick a pen in my pocket.
So if you notice, the tape's got zeros on it.
Yes.
And because this is an absentee machine, it's every precinct, all 6 precincts. So you'll see each municipality and the contacts for that municipality. And we're at public count 0, so we're going to do this. And since this will be a cumulative total, we at this point are just going to roll the tape up and power down the machine. And then I'll put a new seal on it. And
And the public count is 2.
the public
Yes.
count is 2. Thank you.
And so this is when in all the precincts on election morning, and if the early voting site on the first day, the machine's brought out, opened up, and this is opened up where the tape is, and you bring the tape out, the machine prints the identifying information, and then when you open the polls, it prints a 0 tape, show there are no votes on this machine. And then that gets folded up and it goes back into the compartment until the end. And it stays attached to one of the final sheets. And there are 3 sheets. One goes in the ballot box, one gets mailed back with that 0 tape, and one comes back here with the chief's badge. But it's this same process in each precinct.
There's been some discussion about putting the tape back in here.
I usually roll it like in a little tube.
Yeah,
But-
it-
November 12th, counting down.
I think it'll work.
You mean it was a problem or?
Well, for the 300 stake, there wasn't as much space, but it
Yeah.
doesn't seem to be that different for me. So.
No, it's not, I'm not. My older son says, hey, ask him if the script works and make us display.
You're rolling. You're rolling. It's nice to see you on this side of that, you know?
That's
And did they tell you to?
I know I can't. So I'm not.
Right, right.
I got that one down. Right. 4 weeks ago. And then today I looked at my years. Yeah, I was able to do the whole thing.
This one?
So if you guys just want to verify this deal that was written, yes, right here. And it's on next week's because that's the one I cut. And that one will stay the same. I can type it. Anywhere by this valid approval date, yeah.
Sorry.
Madam Director, are you ready with your report?
A couple of things. We completed the logic and accuracy testing successfully on September 26th. And attendance was staff, board member Karen Blows, and then we also had our FST state representative Tia Reddick, and then we had one precinct official, Tom Moran, also help. So we had a bipartisan mix as well as the state observance for that, and that was completed successfully. We also held a mock election, which is basically just uploading the results from the LNA testing from those ballots that were put through and tested to the state. That was done successfully. We did several imports of election results on October the 2nd. So that was done successfully. Absentee ballots began being mailed out on October 3rd. To date, as of today, we've sent out a total of 28 absentee ballots, and that's a mix of civilian, military, and overseas. And of course, we've received 2 back, 1 military, 1 over, 0 civilian so far. We have received back 6 updated registrations with ID information from in response to the state's letters. So we have had a few more trickle in just by chance, or people that found out some other way that they were on the list. But in response to the state's mailing for the registration repair of people on our list that did not have ID information, we've received 6 back. So that's a pretty good. We've just had barely over 100, so I think we're chipping away at that list. Precinct official training will be held October 8th and 9th. October 8th, we just have one municipality, it's Duck. They're the only one that's labeled, so if you are planning to attend, we encourage you to do so. I would say come on the 9th. It'll be a larger group, a much more comprehensive training. This training is not open to the public. Voter registration deadline is October the 10th at 5 p.m. Early voting begins October 16th, and our next board meeting is Tuesday, October the 17th at 3 p.m. This will be our second absentee meeting, more than likely, other than approval of minutes no other business but absentees, so should go fairly. Oh, is it?
What's that?
14th? Sorry, October 14th. Yes, you're right. And that's all I have.
Okay, thank you. I don't have anything. Does anyone else on the board have anything? John?
The chair had encouraged the members to attend the training sessions. I will not be available for Thursday. I was planning on coming tomorrow. So if that's okay?
Yeah.
All right, so I'll be in attendance tomorrow.
I would just like to say I attended the logic and accuracy testing process that was done by staff. And I thought that it went remarkably well. And I would like to applaud our staff for the thoroughness and patience they exhibited in going through all the steps of the testing in order to demonstrate the efficacy and accuracy of our new equipment and our process. It was professionally done, and it was impressive to see just how thorough the staff was in making sure that every machine was going to perform before we sent those machines out into the world to be used for the first time. So kudos to the team that did the logic and accuracy testing day. And I will be in attendance on the Thursday.
Okay. Yes, you guys always do an excellent job, and you deserve recognition almost every day of the week, I must say. It is my plan to be at both trainings. Fingers crossed, I'll let you know if anything changes. Randy, do you have anything?
No.
All right. Is there a motion to adjourn?
I move we adjourn the meeting.
Is there a second?
I'll second.
All in favor?
Aye.
Aye.
This meeting is adjourned at 3:49 PM.